Hello, and welcome to the Fair Housing Project's presentation on the Fair Housing Act after Bostock. We are going to cover a range of topics, starting with an introduction to the project and to community legal aid, and finishing our housekeeping with a couple of practical matters. From there, we will get started on the substance of this presentation: why fair housing laws exist, what the Fair Housing Act does, how the United States Supreme Court's decision in Bostock versus Clayton County impacted the Civil Rights Acts, subsequent U.S. Department of Housing and Urban Development guidance on Bostock vis-a-vis the Fair Housing Act, and a few practical examples of discrimination in the rental housing market. Community Legal Aid is a nonprofit organization that provides free civil legal services to qualified individuals in Worcester, Hampden, Hampshire, Franklin, and Berkshire counties. The Fair Housing Project is a program of community legal aid and serves central and western Massachusetts. Not only do project attorneys do legal advocacy under the Fair Housing Act and Massachusetts state anti-discrimination laws, project staff also conduct educational workshops and manage a fair housing testing program. For today's presentation, there are two key things we ask you to keep in mind. First, none of this information constitutes legal advice. While we hope that you learn about some newer developments in the world of anti-discrimination law, this content is meant to inform, not advise. Second, there is so much more to learn and explore when it comes to fair housing in general and protections for Two-Spirit LGBTQIA+ individuals specifically. Please feel free to continue learning beyond this presentation. With housekeeping out of the way, let's turn our attention to the laws and their purpose. The Fair Housing Act, adopted into the Civil Rights Act in 1968 as Title VIII, was the product of over a century of postbellum housing inequity and decades of concerted efforts to institute anti-discrimination protections in the housing market. To maintain white supremacy in the wake of the American Civil War and ensure that property ownership continued to be a privilege of white citizenship, homeowners began including covenants in their deeds that barred non-white people from purchasing those houses. These racially restricted covenants were popularized in the North's Twin Cities, Minneapolis and St. Paul, Minnesota, and were guided by a central tenet that mixed-race residential areas were hazardous and should be eliminated. Combined with real estate practices like steering, racially restricted covenants manifested neighborhood racial segregation. By the 1929 market crash, the unchecked myth that Black people and most immigrants posed threats to the health of white neighborhoods drove the eventual creation of these maps that you see on this slide. You might not have seen one of these maps before, but it's very likely that you have heard of them at some point. These are the Homeowners Loan Corporation's residential security maps, better known as redline maps. During the Great Depression, the United States government came up with an idea that would remobilize the country's white middle class, a program where the federal government itself would back home mortgages. This way, people could access loans that were guaranteed by the federal government so that they no longer had to front the entire cost of purchasing a house. However, the federal government was not going to back mortgages without performing its own risk assessment. Holk dispatched examiners across the country to research and evaluate the supposed health of a city or town's neighborhoods and make determinations about which neighborhoods were worth federal investment. The field manual instructed Holk examiners to consider the homogeneity of neighborhoods when making their determinations. Make no mistake, this was an instruction to value mostly or all white neighborhoods higher than non-white or mixed-race neighborhoods. Other considerations like the prevalence of multi-family homes or apartment buildings would negatively impact a neighborhood score. Together, these characteristics valued wealthy, upwardly mobile white families pursuing single-family homeownership over all others. Green neighborhoods received the best scores. Blue neighborhoods were also considered safe and worthwhile investments. Yellow neighborhoods were found to be definitely declining, and red neighborhoods were called hazardous. The maps you see here represent Holk redline maps that were made within Community Legal Aid's service area. We have maps for Fitchburg, Worcester, Springfield, Holyoke, Chicopee, and Pittsfield. Legally permissible discrimination in the housing market only escalated in the following decades. The Fair Housing Act, first passed in 1968, was signed into law only days after Reverend Martin Luther King Jr.'s assassination on April 4th, 1968. Its purpose? to protect people from discrimination when they are renting or buying a home, getting a mortgage, seeking housing assistance, or engaging in other related activities. What's more, the FHA also requires HUD and recipients of HUD funding to not only not discriminate, but to take active steps to further the policies and purposes of the Fair Housing Act. This provision is known as affirmatively furthering fair housing. All told, the Fair Housing Act was a response to systemic housing inequity and is meant to hold housing providers, real estate agents, property managers, and others accountable for discriminatory acts, and it recognizes that eliminating discrimination from the housing world requires affirmative, not just responsive, work. The Fair Housing Act, as well as Massachusetts state anti-discrimination law 151B, prohibits discrimination in housing. Housing discrimination happens when a person is denied housing opportunities or denied access to safe and secure housing because of their membership in one or more protected classes. A protected class is essentially a characteristic of a person. We have listed characteristics that fall under the Fair Housing Act's jurisdiction, as well as additional characteristics protected by Massachusetts state anti-discrimination laws. This means when a person is treated differently because they are Black or because they are transgender, or for any other reason you see listed here, that treatment is impermissibly discriminatory. There are a few things we'd like to note before we transition to Bostock. When a housing provider, real estate agent, property manager, or others deny a reasonable accommodation request without engaging in a collaborative dialogue with the person requesting the reasonable accommodation, that denial, that refusal to even discuss possibilities, could amount to a type of disability-based discrimination. Reasonable accommodation requests can come at any time in the housing process, during the application period, during the tenancy, or even during a summary process proceeding. It is in violation of federal and state fair housing laws to deny housing to someone who is pregnant or who has a child under the age of 6 because there is lead paint in the house. That is a common type of familial status discrimination. Requiring applicants to make 3 times the monthly rent, refusing to accept housing vouchers, commonly known as Section 8, denying an otherwise qualified applicant housing because their income is not from employment specifically, and more are types of source of income discrimination. Source of income discrimination is illegal under Massachusetts state anti-discrimination laws. While some rental properties might be exempt from the Fair Housing Act or Massachusetts General Law 151B, it is important to note that discriminatory statements are always legally cognizable. Further, just because a property might be exempt from these specific laws does not mean that there are not other applicable laws that protect against discriminatory behavior. This brings us to Bostock versus Clayton County, a 2020 United States Supreme Court case that officially expanded the federal definition of sex to include gender identity, gender expression, and sexuality. This single Supreme Court case addressed 3 separate instances of discrimination under Title VII, which governs employment. Gerald Bostock, an employee of Clayton County, Georgia, was a long-term official in the county's juvenile court system who had a strong performance history during his tenure. After openly joining a gay softball league in 2013, the county conducted an audit of funds that Bostock controlled. They eventually fired him for conduct unbecoming a county employee. At the time, Georgia did not have its own LGBT employment protections. Bostock argued that the county's reasoning for firing him was merely pretext for homophobia. Similarly, skydiving instructor Donald Zarda was fired from his job at a Long Island-based skydiving company after Zarda disclosed to a customer that he was gay in an attempt to help her feel more relaxed being attached to him during a skydive. The customer and her boyfriend later complained to the company, and the company terminated Zarda's employment, claiming he engaged in misconduct. Finally, funeral home employee Amy Stevens, who presented as male when she was hired, came out as a trans woman to her employer and let them know of her intention to access gender-affirming medical care. Harris Funeral Homes fired Stevens shortly after she sent her letter and reasoned that they were a religious organization covered by the Federal Religious Freedom Restoration Act and were thereby entitled to terminate Stevens' employment. Harris Funeral Homes also argued that Title VII did not cover transgender people, so Stevens did not have a Title VII sex-based discrimination claim. The U.S. Supreme Court agreed to hear these three cases, again consolidated under Bostock versus Clayton County, because federal courts of appeal across the country were interpreting the meaning of sex under Title VII differently. This means that in some regions of the United States, courts agreed that sex included protections for sexuality and gender identity and expression, while other courts disagreed. Since all federal courts have to follow U.S. Supreme Court decisions, this case presented an opportunity for the Supreme Court to set the proverbial record straight as to the meaning of sex under Title VII. In a 6-3 decision, the Supreme Court interpreted the statute to mean that Title VII sex discrimination necessarily extended to sexual orientation and gender identity and expression. In the law, this kind of reasoning is called but-for causation. Remember when we said that discrimination happens when an adverse decision is made because of someone's race or sex or religion or any other protected characteristic? That question of why a housing provider or employer made the decision they made is a question of cause. Justice Neil Gorsuch, writing for the majority, said that an employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids. So, had Amy Stevens been assigned female at birth, Harris Funeral Home would not have terminated her for her intention to comply with the employee handbook's rules on how women should dress in the workplace. Had Donald Zarda or Gerald Bostock been cisgender women, their attraction to cisgender men would not have led to the termination of their employment. It is only because they are cisgender men that their attraction to other cisgender men became an issue for their employers. Therefore, each of their employers fired them because of their sex. Such reasons constitute illegal discrimination under Title VII of the Civil Rights Act. If you've noticed that Bostock versus Clayton County was a Supreme Court decision about employment discrimination, and we are here talking about the Fair Housing Act, you've picked up on something important. Title VII is not Title VIII. The Supreme Court expanded sex under Title VII to include sexual orientation and gender identity and expression. Here's why that distinction, though, is irrelevant. In short, other branches in the federal government caught on, and relevant administrative agencies responded in kind. Following a call to action in a presidential executive order, the U.S. Department of Housing and Urban Development, or HUD, published guidance in 2021 on the impact that the Bostock opinion had on the Fair Housing Act. Even though the Fair Housing Act is not Title VII, each of the broader Civil Rights Act's component parts are very similar. This means that the reasoning the court used to expand the federal definition of sex under Title VII has to apply to other similar provisions. The court's logic is not employment specific, so it tracks that Title VIII's definition of sex would parallel Title VII's. We don't have to rely on this logic, though. HUD's guidance tells us about the relevant impact on the Fair Housing Act. This memo foregrounds HUD's mission to ensure that all people peacefully enjoy a place they call home, where they are safe and can thrive, free from discrimination and fear, and says that this mission cannot be accomplished without including LGBTQ people under FHA protections. Essentially, Title VIII's definition of sex officially includes sexual orientation and gender identity and expression. In application, this means that housing providers, property managers, real estate agents, and others cannot legally treat applicants, tenants, or others differently because of their sexual orientation or gender identity. Please note that this also includes assumptions of someone's sexual orientation or gender identity. It is officially legally not okay to treat someone differently because they are actually gay, or you think that they are gay, or trans, or bisexual, or if you think they aren't presenting themselves in accordance with what you think their gender or sexual orientation is. What might discrimination based on a person's sexual orientation or gender identity and expression look like? Well, it can look like a lot of different things. Here are a few concrete examples, but remember, this is not an exhaustive list. The first example is probably the one most people think of when they think of housing discrimination: refusal to rent an apartment. Not only would rejecting a completed application from a qualified trans person because you don't want trans people living in your properties be a tangible instance of illegal discrimination, so too would refusing to reply to inquiries about available units made by trans people when that refusal to reply is based on the potential applicant being trans. Now, let's say you have a standard reply to all initial inquiries for your available units, which means everyone, regardless of gender or sexuality, receives the exact same response when they reach out by email. That's fine. But what if you offer to show the apartment to cisgender or heterosexual applicants first? And only if you can't fill all of those time slots do you offer to show the apartment to Two-Spirit LGBTQIA+ individuals. That difference in treatment, offering to engage in the rental process with cisgender or heterosexual applicants over Two-Spirit LGBTQIA+ applicants because of those applicants' sexuality or gender, is the discriminatory act. Say you offer the same opportunities at the same time to all applicants. Great. But then you quote different prices to some applicants because their sexuality or gender identity and expression. Or you don't offer the promotional price to transgender or other Two-Spirit LGBTQIA+ individuals that you do for others. Maybe you're willing to do yard maintenance for cisgender or heterosexual tenants, but you tell other applicants that they will be required to do yard maintenance themselves. What if you set up apartment showings for everyone who asks to see the unit, but you tell those you perceive to be Two-Spirit LGBTQIA+ applicants an incorrect move-in date, or tell them that the apartment was just rented when it really wasn't? All of these examples violate the Fair Housing Act and Massachusetts state anti-discrimination laws. There are a myriad of other ways that discrimination can play out in the rental process. So just remember that the essential question is whether differences in treatment is based on whichever protected characteristic from a couple of slides ago. Okay, you've treated every applicant equally and have transgender and gay tenants. Excellent. What if you don't respond to their repair requests or concerns about living conditions, but you respond to repair requests and other concerns from cisgender or heterosexual tenants? What if you respond to everyone's requests, but you instruct the maintenance person to fix other units before addressing issues in your trans or gay tenants' units, regardless of if their problems are more urgent than their neighbors? Or let's say that you or your company just purchased an apartment building and you want to terminate all existing tenancies so you can repair every single unit and rent those renovated units for more money. That's allowed, right? But maybe you serve proper identical notices to quit upon every tenant, and cisgender as well as transgender tenants ask to negotiate a move-out date so that nobody has to go to court. If you only negotiate different move-out dates, if you only offer to extend leases for a short period of time to the cisgender tenants, but not the transgender tenants, that's also an issue of discrimination under applicable fair housing laws. Hopefully there's an obvious pattern in all of these examples. Two-Spirit LGBTQIA+ individuals are being treated differently because of their perceived gender identity and expression, or their perceived sexuality. Ultimately, whenever an adverse decision is based on someone's sexuality or gender identity and expression, regardless of if those assumptions about their sexuality or gender are correct, that decision constitutes discrimination under federal and state anti-discrimination laws. We could keep discussing examples of discriminatory behavior for quite some time. Instead, we encourage you or your organization to seek counsel, legal advice, or additional learning opportunities if you want to know more or you want to take a deeper dive into the world of fair housing. These are some of the resources that we consulted for this presentation. Please feel free to start here if you would like additional information. This is, of course, nowhere near an exhaustive list of primary authorities and secondary information. With that, we thank you for watching. The work that provided the basis for this presentation was supported by funding under a grant with the U.S. Department of Housing and Urban Development. The substance and finding of the work are dedicated to the public. The author and presenter are solely responsible for the accuracy of the statements and interpretations contained in this publication. Such interpretations do not necessarily reflect the views of the federal government.